Hello friends, I am Dr. Ankit Srivastava, Assistant Professor of Law at Rajiv Gandhi National University of Law, Punjab. To understand trespass to goods, it is important to first understand the meaning of trespass. One could define trespass as an action that goes beyond what the law allows. It is an unjustified, purposeful meddling with someone's property. Here, the word intention suggests that the wrong was done willingly. Trespassing involves directly interfering with another person's property or their right to enjoy it, possess their belongings, or move about freely. Trespass is of various kinds. For example, trespass against a person is said to be committed when there is an unreasonable interference with the body of a person, either by causing actual harm or by causing an apprehension of force. Trespass on a person implies that there is direct or intentional interference with a person's body or liberty. Similarly, trespass on goods is said to be committed when a person unreasonably or wrongfully interferes with the goods or movable of others. It may comprise taking the goods from another, spoiling or causing damage to those goods, or even simply moving them from one place to another. The loss or damage caused must directly have an impact on the goods themselves. It is also crucial to remember that trespass on goods is based on interference with the possession of the goods and not the title. A person in possession of who has the right to possess can make a claim against a person who trespassed on his goods. A person in possession of the goods has a right to maintain trespass against every person except a person who has a better title over those goods. It has its foundation in the taking and carrying away of property from the plaintiff's possession, that is, the commission of an asportation. Direct interference with the actual possession of the plaintiff needs to be established to make out the tort. In simple words, if there is a direct act that causes damage to goods by seizure or removal from someone, then it is called trespass on goods. For example, removing a tire from a motor car, beating or killing the animals, infecting them with the disease, chasing the animals to make them run away from the possession of the owner, or killing a dog by giving it poisoned meat. Now, moving ahead, let's talk about the historical context of trespass to goods. Understanding the legal idea of trespass to goods is important for anyone who wants to comprehend its historical basis, rooted in property law development that dates back many centuries. Over time, property ownership ideas have been at the core of societal structure and governance. In ancient cultures such as Mesopotamia, Egypt, and Greece, property rights were recognized and enforced through differing jurisprudential systems. The Code of Hammurabi, which originates from ancient Mesopotamia around 1754 BCE, has some provisions dealing with ownership of properties by individuals and what happens when some people unauthorizedly interfere with their possessions. Similarly, ancient Greek and Roman legal systems took cognizance of property rights, resulting in the establishment of processes for resolving property-related disputes arising out of encroachments or damage. Feudalism was a medieval European social system where land ownership played a central role in determining the overall feudal pyramids organization. Feudal lords possessed large estates while peasants worked on them. Trespassing on the landlord's property or interfering with his or her property was considered a very serious offense, carrying severe penalties in most cases. Trespass to goods as a concept continued to develop during the Middle Ages, and this resulted in several common law principles that dealt with conflicts emanating from interference with movable possessions. In England, trespass-related torts were identified by the common law, which included trespass to chattels, trespass to land, and trespass to goods. These concepts form the basis of modern property law and provide a system for resolving disputes over ownership. As European powers expanded their influence through colonization and exploration, legal concepts related to property rights and trespass were exported to other parts of the world like India. The colonial rulers imposed their legal systems on indigenous populations, including elements of English common law. However, traditional customs and practices associated with owning property survived as well, resulting in a complex relationship between indigenous laws and colonial legal systems. In India, the British colonial administration introduced English common law principles through legislation and judicial decisions relating to property rights and trespass. The Indian Penal Code of 1860 was largely modelled on English criminal law. It defined various criminal offences involving encroachments upon land or buildings or damage thereto, stealing or causing impairment to personal property. Adding to that, Indian courts have had judicial decisions on trespass on goods influenced by English legal precedents, thus providing more clarity on the rights and liabilities involved. Indian legal system, nevertheless, reflects its diverse culture and historical context despite its colonial legacy. In order to cope with emerging property rights, concerns related to trespass and statutory laws, post-independence Indian legislators enacted regulations that considered a rapidly developing country's socio-economic realities. This includes legal reforms and judicial activism, which have enabled the adoption of legal principles to meet the needs and aspirations of the diverse population of India. To sum it up, the historical perspective of trespass on goods offers valuable insights into the development of property law as well as applicable rules in personal property relationships. The concept of property rights and their protection has been vital for all societies from ancient times until today, when mankind is organized into nation states. However, we can better comprehend why it holds an important place in modern laws and affects individual rights towards possession if we look back into past events that brought about this terminology through its role in shaping modern-day jurisdictions. Moving on to our next topic, let's talk about essentials of trespass to goods in both civil as well as criminal perspectives. Trespass on goods encompasses a range of actions that interfere with the possession or enjoyment of another person's movable property. Whether viewed from a civil or criminal standpoint, the elements of trespass on goods remain consistent, though the legal consequences and remedies may differ. Let's first see the civil perspective of it. In trespass on goods, a person's rights over his or her property are usually infringed, leading to damage, loss, or deprivation. In India, civil trespass on goods is mostly guided by the law of torts, which covers many wrongs or injuries caused to others that result in injury or loss. Although there is no specific statute that deals with civil trespass on goods, there are several legal principles and precedents that govern the settlement of cases involving unauthorized interference with chattels. To establish a case for trespass on goods within a civil action, generally the following must be shown. The first is interference. So, the ownership interference can take different forms, such as wrongful possession, damages, conversion, and disposal of the property. Next is intent. So, while intent to trespass is not always necessary in civil cases, it may strengthen the plaintiff's claim. If the interference was deliberate or intentional, it may indicate a higher degree of culpability on the part of the defendant. The next is possession. The plaintiff must establish that they had lawful possession or control over the goods at the time of the trespass. This may involve providing evidence of ownership or lawful authority to possess the goods. Next is damage or loss. The interference must have resulted in damage, loss, or deprivation of the plaintiff's rights or interest in the goods. This can include physical harm to the goods, impairment of their functionality, or economic loss suffered by the plaintiff. The major redress that trespass on goods can award in civil litigation is damages. The court may grant the plaintiff damages to make up for any damage or loss occasioned by the entry. Furthermore, the court may issue an injunction to stop the defendant from continuing with the trespass or interfering further with plaintiff's goods. In conclusion, trespassing on goods as a civil wrong under Indian law provides individuals who feel aggrieved with property rights protected by various mechanisms. Trespass on goods such as wrongful possession, damage conversion, or disposal of movable property without authority from the owner could result in injury, loss, or deprivation. Key elements that must be proved for trespass on goods to establish civil liability include interference with the plaintiff's possession or enjoyment of the goods, intent, lawful possession of the plaintiff, and proof of damages or losses suffered due to trespassing. Let's now see the criminal perspective of it. In criminal law, trespass to chattels is typically a misdemeanor or felony depending on severity and intent. Generally speaking, proof of culpability beyond a reasonable doubt requires that 1. That it should be unlawful interference, that is, that the defendant unlawfully interfere with another person's property. The act can include theft, damage, destruction, and conversion of the property. Next is intention. Now, criminal wrongs committed against goods sometimes require proof of intent by the defendant. In this case, it must be shown that the defendant knowingly undertook the trespassing with a mental attitude consistent with this particular offense. Next is possession. Like in civil cases, for this crime to be proved beyond reasonable doubt, it must be shown that another person had ownership rights or some other legal interest in the property that was interfered with by the accused. This might involve proving that the complainant owned or was the rightful possessor of such items. The next point is criminality. For one to be charged with criminal trespass on goods, his actions should amount to an offence under statute or common law as well. Depending on the jurisdiction and circumstances of the case, this may encompass particular offence like burglary, theft, larceny, or criminal mischief. The consequences of criminal proceedings for trespass on goods can range from fines and probation to imprisonment, depending on how serious and dangerous the offence is. Furthermore, restitution may also be awarded by a court whereby a defendant is ordered to pay damages caused by unlawful entry into someone's premises and the consequent harm suffered by them. So let's look into the relevant provisions of the Indian Penal Code. Several sections of the IPC addresses offences related to trespass on goods and property. These include Section 378. Theft is defined as the dishonest appropriation of movable property out of the possession of any person without the person's consent. It covers situations where a person wrongfully takes or converts another person's property with the intention of permanently depriving the owner of it. Section 425 talks about mischief. So, mischief involves causing damage to or destruction of any property with the intention of causing loss or damage to the owner. It includes acts such as intentionally damaging or destroying another person's goods without lawful justification. Section 426, that is punishment for mischief. Now, this section prescribes the punishment for committing mischief by damaging or destroying property. The punishment may include imprisonment and or a fine depending on severity of the offence. Section 405, criminal breach of trust. A criminal breach of trust occurs when a person entrusted with property misappropriates or converts it for their own use without the consent of the owner. It involves a breach of a fiduciary relationship and typically applies to situations where property is entrusted to someone for a specific purpose. Section 420, that is cheating and dishonestly inducing delivery of property. This section deals with situation where a person dishonestly induces another person to deliver property to them, causing wrongful loss to the owner. It covers instances of fraud or deceitful practices leading to the transfer of property. Section 441, criminal trespass. A criminal trespass occurs when a person unlawfully, without any right or an express or implied license, enters into the private property of another person or remains in such property with a criminal intention. Now, we have talked about both civil as well as criminal liability for trespass to goods. Now, let's talk about available defences against trespass to goods. Defences to trespass against goods are legal arguments or justifications that the defendant makes in order to dispute or mitigate their responsibility for illegally interfering with someone's movable property. In India, as in many other jurisdictions, there are several defences that can be raised in cases of trespass to goods. Depending on the facts of each case, below are some of the defences that may be available. The first defense is consent. So, a common defense against trespass on goods is where a plaintiff declares that he consented to the defendant's acts or interference with the goods. Consent may be express or implied and can be through words, conduct, or prior agreements between the parties. If a plaintiff willingly allowed someone else to handle or use his or her property, this could defeat the element of unprivileged invasion necessary for trespass. The second defense is necessity. This defense arises where the action of the defendant were reasonably necessary in order to prevent imminent risk or damage to the people or things. The defense of necessity may be claimed by defendants who interfere with plaintiff's goods during emergency situations or when they act so as to avoid greater risks. For example, if a defendant took the plaintiff's car temporarily for purposes of taking an injured person to the hospital during an emergency, it may constitute a valid defense of necessity. The next defense is claim of right. A claim of right defense is hinged on the accused's honest belief that they have a lawful right or entitlement to interfere with the plaintiff's goods. It posits that the defendant's acts were sanctioned because he truly believed in his heart that he had the capacity to lawfully exert control over goods. For example, if the defendant mistakenly believed that he or she was the rightful owner of the goods or had a valid lease or license to use them, it may be referred to as a claim of right defense. The next defense is mistake of fact. For instance, if the defendant interfered with goods belonging to the plaintiff due to an actual mistake of fact, it can provide a credible defense against trespass liability. A mistake of fact in this case means ignorance by the defendant about certain facts and circumstances that would have made his or her actions unjustifiable or unauthorized. This defense can only be invoked successfully when a mistake is reasonable and made in good faith. For instance, if the defendant erroneously thought that he or she could utilize the plaintiff's equipment because a third party misinformed him or her about that possibility, it may be viewed as a viable excuse. The next defense is statutory authority. In some cases, the defendant's actions may be authorized or justified by the law, providing a defense against liability for trespass on goods. If the defendant's interference with the plaintiff's goods was expressly permitted or required by statute, regulation, or government authority, it may constitute a valid defense. For instance, if a government agency lawfully seizes the plaintiff's property for non-payment of taxes or as evidence in a criminal investigation, it may be considered authorized interference under statutory authority. The next defense is self-defense. If the defendant reasonably believed that their actions were necessary to defend against an immediate threat or attack, they may claim self-defense as a reason for the intrusion. However, it must be recognized that force must not exceed the magnitude of the danger posed and should be geared towards self-defense so as to avoid liability for trespass. Defenses against trespass on goods are legal excuses by which a defendant can deny or mitigate his responsibilities for wrongful acts carried out on another's property without permission. By raising these defenses, defendants can contradict plaintiffs' allegations and establish good causes behind their conduct. Nevertheless, depending on each case's situation and the principles guiding trespass to goods under law within the jurisdiction concerned, there will be varied applications of these defenses. Defendants need to carefully examine all possible defenses and consult with professionals in order to define their tactics in respect of claims for trespassing upon chattels. In this context, any such defenses are open to the accused. However, it should be remembered that the denial would then rest with him to disapprove of acquisition of trespass over chattels being adequately proved. Now let's understand the difference between conversion and trespass to goods. Understanding conversion and trespass to goods involves grasping two distinct legal concepts concerning interference with movable property. While both revolve around unauthorized actions affecting another person's possessions, they differ in their nature, legal elements, and consequences. Conversion can be described as a civil wrong or tort where a person unlawfully interferes with another's rights to property by assuming ownership of it in a way that is inconsistent with the owner. The aim behind this is to unjustly deprive the owner of his rights or interest in the property, which usually causes enormous harm or loss to him. Conversion comes in different forms, such as wrongful receipt, sale, destruction of assets, and other acts of dispossessing an owner without his permission. It must be shown that there was an exercise of control over property inconsistent with its ownership. Upholding that it could involve taking possession, using it for personal gain, or disposing of it without the authority. Whereas trespass on goods is a legal expression that refers to an wrongful act related to another person's movable property. In such cases, the defendant must either interfere with possession or enjoyment by virtue of unlawful interference with these goods without consent from their possessor. This may include physical entry onto land, causing damage, dispossession, or ejection from it. These include misconducts like wrongful receipt, destruction, and disposal of a thing owned but without consent by its owner, like what am I doing wrong? Unlike conversion, which is about property rights deprivation, trespass to goods focuses on the interference with the owner's possession or enjoyment of the property. So now coming to the conclusion, the exploration of trespass to goods therefore provides insights into the legal framework concerning interference with movable property in India. Trespass to goods is a fundamental concept in property law because it has a historical background dating back to immemorial time and is still relevant today. It is an unjustified interference with another person's possessions, such as wrongful possession, damage, or disposal of property, trespass to goods. To this end, trespass on goods constitute a wide range of actions that may lead to harm, loss, or deprivation for the owner. Knowledge about the elements and implications of trespassing on goods is important for both plaintiffs seeking redress and defendants raising defenses against allegation of trespassing. Trespass on goods historically signifies its significance in property law development from ancient civilization through contemporary nation states. Impacted by the imposition of colonial legal system and subsequent legal reforms, India has imported and modified principles on trespassing onto chattels aimed at conferring them with its socio-economic realities as well as its diverse culture landscape. From a tort point of view, however, proof must be given that there was unlawful interference with the plaintiff's possession or use of the thing and intent while he or she had lawful ownership over the thing. In this regard, damages and injunctions are appropriate means of recourse for victims of trespass to chattels. With this, we come to the end of our today's lecture. Thank you and happy learning.